as per Yusek Sugay, for example nga yung example mo kanina, Sito, na warrantless arrest. Yes, understood, we have warrantless arrest under our law. However, kung titingnan natin yung warrantless arrest under our law is when you have committed a crime or when you have just committed a crime or the police saw you committing a crime, yung tinatawag natin na hot pursuit. Pero dito sa anti-terror law, nakalagay doon, intend to commit a crime. So, even your intent, you're only suspected of intending to commit a crime. So, Sito, imagine, in the previous law that we have for warrantless arrest that we allow, you already committed a crime or you had just committed a crime. So, meron ng crime na na-commit. Itong dinadagdag ng anti-terror law, you are suspected of committing or suspected to intend to commit a crime. So, ang labo nito, how can you even think of the mind of the individual? Wala pang ginagawa. Number one, no? Number two, when you are in the warrantless arrest under previously under our present law, you have to be charged immediately after arrest. Here, you have been detained under a warrantless arrest and you are being detained beyond the required limits of the law, which is 12 hours, 18 hours, and 36 hours. Or in the extreme instance when there is no habeas corpus, 3 days under the Constitution. Here, under the anti-terror law, you are arrested without a warrant, and yet you are detained outside the 36 hours maximum, outside the 3 days maximum under the Constitution, and the ATL is given 14 days plus an additional of 10 days. So that's a total of 24 days, Sito, that you are not being charged of any crime. Worse, if you look at the IRR, ang nakalagay doon, they can arrest you, and if there is no notice from the ATC, the arresting officer can ask for a notice from the ATC after your arrest. So inaresto ka na, wala pang notice from ATC. So it violates, again, another thing, because if you look at it, under our Constitution, only the judges or only the judiciary can issue a warrant. Now, technically, if they ask the ATC for a notice, yung notice from the ATC, that is technically a warrant. So that is, again, outside the realm of our Constitution and our law, because nobody else can issue a warrant except a court. No, here the ATC is allowed to issue a warrant. And another thing that I see at the IRR, which I was bringing up even before during the signing of the law, is that they are always talking about the ATC. However, when you look at here, even the IRR in the ATC, it's composed of 9 members. So when the note, for example, the notice from the ATC, or when the designation of a terrorist as in the ATC, who in the ATC designates or gives the notice? Is it all 9 members? Is it a majority of the 9 members? Is it one of the 9 members? Hindi natin alam. So paano yan? Anong mangyayari ngayon? And when you delist, for example, 9 members say you are a terrorist, nag-apply ako ng delisting. Who delists again? All 9 members again? A majority of that? Paano na naman yan? And if you look at the ATC, nakalagay doon, the ATC has no quasi-judicial or judiciary powers. Malinaw to, very executive powers lang sila. But to decide who is a terrorist, who is there to be detained, who is there to be delisted, those are judicial processes. Paano na ngayon yan? Under the law, which we question, the ATC is formed by 9 individuals. Yun nga, 8 cabinet members and the executive director of the AMLA. So that's 9 members. So cast in stone because nasa batas yan. So hindi sila pwede magdagdag o masama ng iba. They can have assistants or other people to assist them. Pero technically, the Anti-Terrorism Council, as defined under the law, the anti-terrorist law, is 9 members, composed of Department Secretary of Defense, Secretary of Interior, DILG, DOJ, a National Security Advisor, Executive Secretary, yon mga ganon, yun ang mga member, no, and others ng ATC. And as I said, that Siguro dadagdagan ko yung sinabi ni President Egon, yun nga yung checks and balance dito, no? Kasi if you look at it, if you look at the membership, sabi nga natin, those are alter ego, those are cabinet members. For example nga, sinabi nila na determined by the ATC as probable cause. Ang isa sa head doon, di ba, DOJ Secretary. So, saan ka ngayon? So, magque-question ka ngayon sa mga piskal or whoever na member ng judiciary, sila rin ang decide. So the people that decided you are designated as a terrorist, doon ka rin mag-aapela ng delisting. The people who decided there is probable cause to charge you or to put you as a terrorist, doon ka rin maghingi ng recourse to take out that, to question that probable cause. So the question is, how can you now question if they already decided that you are a terrorist or if they already decided that there is probable cause to charge you? Yun ang sinasabi natin, walang checks and balance. And to point out in addition, balance, kasi sinabi ni, going to the statement of Yusek Sugay that you expounded kanina, na yun nga, you give a notice to the human rights, you even give a notice within 48 hours. So you remember, the word used is notice. You did not say that you are being charged in front of a judge. So the judge cannot even decide on your case because the judge only has a notice that you are incarcerated. Unang-una, there is no jurisdiction over the person because hindi ka naman sinusurrender sa korte. There's also no jurisdiction to the subject matter because walang kaso. So how can the judge decide on you? How can the judge even say or give any order in your favor?